you want to see that the contract is followed in the letter and spirit, and both the parties should not violate those terms, then the law of injunction was not existing in the common law courts. The equity court stepped in and said, whenever a contract is made, whenever trust and confidence is reposed, both the parties should follow the contract in the letter as well as in the spirit. That is the reason they evolved the doctrine of injunctions. Here, now, as the law stands today, both the positive aspect of enforcement and preventing a breach of contract both coexist. That is by the relief of specific performance and law of injunctions. Here, there is a leading case on this aspect, which was the earliest case decided by the equity courts. Here, equity courts, that was a case of Lumley, Lumley versus Wagner, 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 Lumley versus Wagner. The facts of this case are that Wagner was a reputed opera singer those days, and Lumley, who was running a casino, entered into a contract with Wagner, and a contract was fixed that Wagner will sing in the opera theater of Lumley for a period of 2 weeks or 3 weeks. And during that period, Wagner shall not perform in any other theater. That was the contract. But what happened was, Wagner got a very lucrative contract and she committed a breach by not performing in the opera theater of Lumley. Then Lumley brought an action against Wagner for enforcement of the contract as well as the negative part of it, saying that not to perform in any other theater. In this particular case, the courts held that no doubt we cannot enforce the positive aspect, that is to compel Wagner to perform in your opera theater during the period of 2 weeks, that's a contract period. But definitely we can restrain Wagner from performing in any theater. That is the reason the court gave a negative relief, that is the law of injunction. That is whereby Wagner was restrained from performing in any other theater during that 2 weeks period, that is a contracted period. But as far as the positive aspect is concerned, the courts never enforced it. That is, they could not compel Wagner to perform in the opera theater of Lumley. That is, in other words, the early conservative thinking of the equity courts was that we can enforce a negative agreement, negative clause, but positive aspect we could not enforce. Then, of course, all of you know, nowadays in all sports, you have what is called central contract which are issued. That means central contracts are given to the cricketers and people from the other fields also, whereby the concerned association promises to pay a lucrative sum towards the annual contract. And so long as a person is under that contract, they cannot participate in any tournament which is outside the purview of the association and without the permission of the parent association. And here, most of the people who are under a central contract, who are paid a lucrative sum per year, and also the prize money, and also the annual, and also the match fees, they cannot participate in any league which is conducted by an outside country without the permission of the BCCI or the Football Federation. But you have found now the trend is that most of the popular cricketers who are past their age or past their prime are giving up central contracts and taking part in all T20 leagues throughout the world. And the latest example is the IPL, which is conducted by the BCCI. Most of the popular cricketers are taking part in it. It is, as far as IPL is concerned, it is rags from riches. Riches from rags rather. A person who has nothing financially, once he is selected in the IPL in any of the franchise teams, he ignores the central contract or does not take up the central contract because he gets much more than what the BCCI would pay. That is a modern trend today. Because after all, when money is concerned, no one would leave it. And nowadays, that's the reason why T20 contracts throughout the world has become very, very popular. But the extent to which our IPL has developed, no other league in any other part of the world has come to that extent. That's why they say India is the biggest bully as far as the ICC is concerned. ICC is terribly scared of India because the financial powers or the money drawing powers, money spinning the powers are only with the BCCI. And cricket is not a game today. Cricket has become a religion. And the legendary cricketers who are there, like Rohit Sharma, Virat Kohli, and all these people, they have become demigods. And Sachin Tendulkar earlier, Kapil Dev, and other people, they had become demigods as far as the public is concerned. So today, what is happening is no person is interested in taking the central contract, but they are taking part in the T20 leagues throughout the world. But one thing is this: once a person is bound by a central contract, he cannot participate in any other league which is not recognized by the BCCI or permission is granted to take part in those tournaments. So, in the case of Lumley versus Wagner, the court said sympathized with Lumley and said, unfortunately, we cannot enforce the positive aspect, that is to compel Wagner to perform in your opera theatre during the contract period, but definitely we can enforce a negative covenant that we can prevent her from performing in any other theatre during the contracted period. That is the 2 weeks time, which was the contract. So that was the only case, of course, which was decided on negative contracts. So what I'm trying to tell you is when the common law said whenever a civil wrong is committed, the punishment was damages used to be awarded in common law courts. But as far as equity courts are concerned, it is said whenever trust and confidence is reposed in a particular person, and the other person who reposes such confidence acts on the trust and confidence, changes his position, which would not have done but for the assurance given to him, then the law would compel him to perform the promise which he has made. That is called the positive enforcement of a contract. That is concisely called the law of specific performance. That is, the contract has to be performed in the letter as well as in the spirit. Then the second thing which they enforced was law is not helpless. Whenever a person wants to commit or violate the terms of the contract, we can prevent him from violating it by issuing a negative relief code or a prohibitive relief or a preventive relief calling injunctions. So these are the two children born out of the law of equity. Then the question arises, sir, in India, are equity prevalent in India? Please remember, in India, we only recognize legal rights. Equity is not recognized in these rights by a separate enactment. But if you see every enactment, I think most of you are advocates, you have the equitable doctrines almost in every enactment. What are those enactments? We will come later. That means in the specific relief act, it is said, suppose an agreement is made between two parties, there is an offer. What are the valid essentials of a contract, sir? Offer, acceptance, capacity, consideration, free consent, and legality of object. That is what Section 6 of the Contracts Act postulates. And when the agreement is made between two contracting parties, both the parties desire that it should be implemented or followed in the letter as well as in the spirit. Or there must be a methodology through which you can enforce that contract. That is a positive relief. That's why specific performance was evolved. Then they can also prevent the breach being committed or the contract being violated. They initiated the doctrine of injunctions. So positive as well as negative was evolved and founded by the law of equity. Then the question arises, sir, which is more superior, the common law courts or the equity courts? See, I think experience has shown, suppose you are a senior, your junior comes up much higher than you. You develop a sort of hatred towards him or jealousy towards him, and you would stop giving him work or or instructing him properly. In the same way, Nowadays, so many factors are coming, sir. What is the rate of property today may not be the rate tomorrow. There is escalation of prices, and human greed knows no boundaries. Here, suppose today you make a contract to sell your property for 75 lakhs. Tomorrow I'm offering 1 crore. Will you sell it for 1 crore or will you sell it for 75 lakhs? Naturally, the greed in a person will prefer to sell it for 1 crore rather than selling it for 75 lakhs. Earlier, the common law courts used to say it is nothing but a civil wrong or a tort where the remedy lies by paying compensation to the wronged person. And we also cannot prevent a wrong being committed or a breach being committed because law of injunction is outside the purview of common law courts. How were common law courts created, sir? Common law courts were created by a charter issued by Her Majesty, the Queen of England. And those days, three courts existed in the Westminster Palace. One called the Court of Exchequer, dealing with financial matters. One called the Court of Common Pleas, which discussed about breach of contract, vagera, vagera. And another was King's Bench or the Queen's Bench, that is presided over by the King or by the Queen. And these were created by a charter issued by, of course, in India we correspondingly we call the ordinance or we call a bill, but in England we call it as a charter. And when a charter is issued by the Queen, the common law courts were created, and one side of the Westminster Palace, the common law courts were located, and on the other side of the common law courts, there came into existence the what are called equity courts. Then the Queen felt because ruling over two-thirds of the world was an headache for the Queen, and, and judicial functions were also given to the Queen, and Queen felt it was a lot of difficulty was there to adjudicate upon those matters. So slowly, what she did was she delegated her functions to her conscience keeper, that is the Lord Chancellor. Lord Chancellor is none else than the Prime Minister today of UK. Now you don't have the institution of Lord Chancellor; they are called the Prime Minister. And slowly, what happened was the equity court stepped in, and they wherever there were defects in the common law, they came as an appendices to the defects and cured the defects of common law. And slowly equity came into existence. Equity is founded on two principles, sir. Whenever trust and confidence is reposed in a particular person, and that person or the other person who reposes trust and confidence acts on the trust and confidence, changes his position, which would not have done but for that representation, the law will compel the person who has committed a wrong or violation to perform his part of the contract. That is called specific performance. And also it can prevent breach or violation of the terms of the contract. It is called injunction. Am I making myself clear to believe this is nothing but a repetition of what we discussed when we were discussing CPC? Then, naturally, sir, you know what you call in Telugu, Savitigola. Naturally, sir, whenever a person takes a second wife, his attraction is more towards the second wife, and the first wife is neglected. All the money is given to the second wife, and first wife is not given anything. She is neglected for all practical purposes because she is a worn out horse. Then what happens? The disputes start between the co-wives. Then Savati Gola laga varsti edi ledu. In the same way, what happened was there was a conflict between the common law courts and equity courts, and the question was who was more superior and who is inferior. And that was a famous case of Addington was versus Lord Coke. Lord Coke was the presiding chairman of the common law courts, or the chief justice as you may call it, and Addington was the Lord Chancellor at that particular time. This arose in the 16th century. And then the conflict between both of them as to who is superior and who is subordinate arose. Then naturally, sir, they approached the Queen, and Queen was asked to decide the dispute. The Queen, what she cleverly said was, Equity courts have stepped in because of the inadequacies of the system prevailing in the common law courts, and it has come to pep up the law, rejuvenate the law, and give a remedy which was not available in the common law courts. Both one is not superior and one is not inferior. Both have got equal rights, and each has got its own sphere of activity. Naturally, sir, suppose this gentleman is Mr. Redmi. Suppose, let us say, he is a prosperous advocate. Tomorrow, his junior exceeds him. Then what happens is there's a conflict between both of them. And both of you worked under a super senior. Then both of you go to the super senior and say, sir, who is superior and who is inferior? The super senior says, don't bother, sir. Both of you have got equal IQ. I want the services of both of you. Please don't fight between yourselves. Each one knows the law well, and each one is superior to each other. So no one is superior to anyone. So the Queen cleverly said, the equity courts have come in not to destroy the law, but to provide the vitamin M and cure the inadequacies of common law. That is, it acts as a pep up of the common law system and the judicial system, and see that the reliefs are given which molds to the particular scenario which exists. That's how the conflict was resolved, by saying both of you are equal. Both of you are like two eyes to me, and without two eyes I cannot see. The same way, common law exists on one side of the Westminster Palace, and the equity courts exist in the other side of the Westminster Palace. So far, so good. So that's how the equity system developed. And in fact, in Telugu, they call it as equity means samanatvam or barabari, as we call it in Hindi. Here, what happens is equity means don't bother about the technicalities of law, rigors of law, or the difficulties which you face in enforcing a law or implementing a law. Make the law more clear. Try to mold the relief in such a way that the person who cries for justice meet out justice to him. Don't go on technicalities. That is the reason the equity courts are not bound by the technicalities of law. They mold the relief in such a way that a person who knocks the doors at the seeking equity jurisdiction, courts come to their rescue. That is why it is said in jurisprudence, justice should not only be done, but deemed to be done. That's how the equity courts came in. Then the question arises, sir, in India, have we got a separate law of equity? Let me tell you with my full confidence and my experience that separate law of equity does not exist in India. In India, we recognize only legal estates. In India, we do not recognize equity, but the equitable principles are found in almost every enactment. Let us take the specific relief act. If you take the equitable principles, now we know, all of you know by this time, because most of you are practicing advocates, you can, whenever an agreement is violated, you can always go to the court and ask for specific performance of the agreement. What do you mean by specific performance? Specific performance means to follow the agreement, implement the agreement, enforce the agreement, both in the letter as well as in the spirit. That's how specific performance is. Then you have got, when the other side is committing a mischief, when the other side is violating a mischief, violating the law, violating the contract, is the law helpless to come to the rescue of that person? The law definitely comes to the rescue of that person and issues a preventive or a prohibitive relief called injunctions. And in various enactments, you can find equitable principles, sir. If you take the Transfer of Property Act, Section 109 of the Transfer of Property Act, of course, I'm not dealing with Transfer of Property Act now, but 109 of the Transfer of Property Act says what is called is, suppose I have got a defective title. I do not have title to the property, but I induct you into possession of the property, and you have recognized me as your landlord, and you are paying me the rent, and you are in occupation of the property because I permitted you to stay in the property. Then you cannot set up as a tenant, you cannot set up title in a third person and say both of you fight, and in case one of you succeed, then you call yourself as a landlord, then I'll obey the terms of the contract, terms of the lease. That is not there. This is what is called possessory estoppel. Possessory estoppel means this is the creation of equity, please. Possessory estoppel means whereby trust, whereby letter, spirit, and implication, and expressly you admit me as your landlord, or you acknowledge me as your landlord. You pay rents to me. I am the person who has inducted you into possession. You are answerable to me and not to a third person. You are stopped from denying my title. And please remember the consequences of that is that you cannot question the wires or the legality of the notice of termination which I have served on you. That is what is called promissory estoppel. This is also a child born out of equity. Another thing which was born out of equity is section 43 of the Transfer of Property Act, which talks about feeding the grant by estoppel. What do you mean by feeding the grant by estoppel? That is, let us say on the date of transfer, I do not have any title, but later on, I acquire title to the property. I paid the consideration. I have also acted bona fide in good faith, thinking that you have got title. Subsequently, it turns out that you do not have title. Then, in that case, subsequently, suppose let us say I acquire title to the property by any mode. I will be stopped from asserting that I had no title on that day. Today I have acquired title. I don't want to pass it on to you. The doctrine says feeding the grant by estoppel. That means on the day of transfer, suppose I don't have title, subsequently acquired title by any mode, the subsequently acquired title perfects an otherwise incoherent or imperfect or defective title. And the person who transfers the property to another person and the other person acts in good faith, bona fide, and for consideration. Are you audible, madam? Everyone, please. Because there is some problem, technical problem because of the rain, sir.
Yeah, it is audible, sir.
Thank you, sir. Thank you very much. Thank you. So I proceed further saying that the subsequently acquired title feeds yeah, feeds otherwise a defective or imperfect title, and the person who has transferred the property cannot deny his authority and cannot refuse to transfer the rights which he has. This is what is called feeding the grant by estoppel. That is section 43 of the Transfer of Property Act. Then one more thing you got where section 37 or 38 of the Transfer of Property Act, which says sale by ostensible owner or doctrine of holding out. Here before
Not audible, sir.
yes, thank you, sir. I go by the doctrine vigilantibus, 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 non-dormantibus, non space dormantibus, 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 jura, jura space subvenient, subvenient. What does it mean? It means that I must always be vigilant about my rights. I must also be conscious of my rights. And I must go to the court at the earliest available opportunity. Suppose I sleep over my rights for 20 long years and wake up like a Rip Van Winkle. In the meanwhile, property has already been transferred. Many things have happened. Let us say it happens in a scenario where I execute a power of attorney in favor of a third person, giving him authority to sell the property. And the person to whom the property is sold purchases the property bona fide means with good faith, and makes all inquiries possible and then purchases it. And to the public, the real owner holds out his agent as a real person entitled to sell the property. Then the real owner cannot go back on his authority which is given to the power of attorney. This is what is called doctrine of holding out. Here also, equity steps in. That's how it's also said sale by ostensible owner. I tell you what by ostensible owner means. Please remember it has got an excess. I just cannot go to specific real fact without giving you this history. Sale by ostensible owner. Ostensible means pretend owner. Suppose, let us say, you give a power to a power of attorney, get the power of attorney registered, and the power of attorney represents to the public that he has got full authority, express or implied of the real owner, and he has got full capacity to sell the property. Then he sells the property, and the other side makes all inquiries possible and also gives a paper publication and also acts in good faith and also pays the consideration under the impression that the ostensible owner or the power of attorney has got the powers to alienate the property on behalf of his principal. Then in that case, the title of the purchaser is protected, and though the person who sells the property holds himself as the ostensible owner and the real owner keeps quiet without checking it properly or sleeps over his rights, law will come to the rescue of a person who has been wronged, and the person who is the real owner cannot open his mouth. That's where equity steps in. I mean, making myself clear to please. Now we go further, coming to the purport of the specific relief act. Another example also I can give you, sir. That is, suppose, let us say, open land is let out to a tenant, and the open land is improved, and also structures are put in there, and the person to whom the possession has been delivered acts in good faith, bona fide, thinking that he has got authority to make improvements, and the real owner keeps quiet without checking it properly. Then whatever improvements are made by the tenant or by the lessee, the landlord has to compensate him the money which he has spent for renovation. This also is not the law, but it is founded on what is called equity. So, what I'm trying to tell you is the equitable principles are initiated and incorporated in various enactments, though not in the specific relief act. Then we come to what are the two principles which govern equity. Here, two principles are: one who comes to equity must come with clean hands. And the second doctrine is one who seeks equity must do equity. I'll come one by one. One who comes to equity must come with clean hands. What do you mean by that? Doesn't mean that you wash your hands with soap and then come to court. No. All relevant facts which are relevant, which are crucial for determination of the disputes involved in the controversy, has to be fully disclosed, and there shall not be any suppression or concealment of material facts. Because there's a provision in Civil Procedure Code, Order 6, Rule 2, that is plead and then prove, not prove and then plead. Don't take the other side by surprise. Don't try to conceal or suppress any facts. Don't think that the other side is a fool, he does not know it. So, as and when he knows it, he can pin you down. That is the reason once you seek the equity jurisdiction, you must be above board. That is, your chastity should be something like the Caesar's wife. That is, you shall not be the wrongdoer. I also gave an example yesterday or day before. That is to say, you are yourself the wrongdoer, but you say that the other person is the wrongdoer. No. Is something like in English they say kettle calling the pot black. That is, kettle was trying to ridicule the pot by saying, look, how ugly you are looking. You are so black. Then the pot shot back, sir, you are no better. You are also black. How can you call me black and ugly? You are also black and ugly. So, in other words, suppose you are the wrongdoer and you say that the wrong has been done to you, you must try to explain everything. And when you say that the other side is the assailant or the other side has violated your rights, that means all the cards will have to be laid on the table and no suppression or concealment should be there. In other words, full disclosure has to be made in order to have a transparent litigation. That is the first doctrine, sir. The second doctrine is one who seeks equity must do equity. Please remember, as far as all equitable reliefs are concerned, they are not available to you ex debito justitiae, ex space debito, debito space justitiae. JUSTIAE. What do you mean by that? Ex debito justitiae. Ex debito justitiae. Ex debito justitiae. That means not available to you as a matter of right. It is a discretionary remedy which can be exercised by the courts of equity only when certain circumstances exist. I will tell you, sir. Uh, that is, what do you mean by that? It's a discretionary remedy. That means when you come to the court, ask for enforcement of an agreement which you have entered into with the other side is the violator, then you will have to give the circumstances of violation, how you have performed your part of the contract and the other person has not performed his part of the contract. You are the wronged person and the other person is the violator. And also, when you want a property to be sale deed to be executed and registered in your favor, you must aver and allege that I am ready and willing to perform my part of my obligations and that I have been put in position in part performance of my contract and the other side is not performing his part of the contract. Then I have also given him a notice calling upon him or reminding him to perform his contract, which he has not done so. Then you can get that agreement enforced in a court of law. Suppose you don't have a penny in your pocket, but still say, I want to purchase a property for 75 lakhs. In Telugu, they say, Korikale Gurralaite. You don't have anything. You are yourself a pauper, but still say you want to purchase it. Law will not come to your rescue because it's a discretionary remedy that is available to you and not as a matter of right. It is a discretion of the court whether to grant or not to grant. So these are the two pillars on which the equity jurisdiction rests. Now we go into the subject, please. As far as the specific relief act is concerned, it has been amended from time to time, and the present enactment which we are following and implementing is the specific relief act of 1963. I will go into the smaller reliefs first before we come to the bigger reliefs. First and foremost, we go to section 6 and 7. What does it mean? It means it provides for a summary suit. Again, I repeat, 6 and 7 provides for a summary remedy where a person, please follow, please, where a person has been wrongly dispossessed from the property, where a person has been wrongly dispossessed from the property, otherwise done by due process of law, or he has been deprived of his position, though he is prompt and regular in performing his obligations, then he can ask the court to be put back into possession by filing a suit and within 6 months of his disposition. Please remember, landlords have got different means to get rid of tenants. They can first remove the fuse, they can remove the electricity meter, cut off the water supply, cut off the pipelines, remove the motor which is used to pump water, and also prevent water and electricity being used. These are all basic necessities for every individual. Then in that case, and he has been dispossessed also. Then in that case, within 6 months from the date of disposition, a summary suit can be filed against your landlord claiming repossession of the property or to be put back into possession of the property, and it is a summary relief that is granted under section 6 and 7. The only condition is you must say that you are in possession on that particular day and that you are dispossessed from the property. Dispossessed bole to you have been evicted or you have been thrown out of the property without any lawful excuse or justification. Then the landlord has played that mischief, sir. Please undo that mischief and put me back into possession of the property. A summary suit can be filed within 6 months from the date of disposition. That is section 6 and section 7. Then we go to, I'll deal with specific performance in the end, please, because it's a bigger chapter, that is section 10 to section 22 of the specific. Before that, I'll finish the smaller sections. Section 26 of the specific relief act speaks about rectification. What do you exactly mean by rectification? Rectification means rectify. Rectify means correct, alter, so on and so forth. Nowadays, you find revenue entries in the revenue records are tampered. Suppose let us say LIA is the possessor of the property or LIA is the pattatar of the property. His name is unceremoniously removed and some other pochaya comes in that way. Or the revenue records earlier shows your name in the revenue records, but your name has been removed and some other's name has been inserted. Or in a sale deed, let us say mostly, sometimes please remember, I think most of you are now in the information technology age where technology has developed to such an extent you can make a donkey into a horse and a horse into a donkey. But please remember, computer has no brains. Computer has, you have only to feed the computer. The data has to be fed by you. Suppose let us say you feed a wrong data, then the computer also reproduces it. It has no brains to think whether what it is typing is correct or not. Then what happens is sometimes it so happens, suppose a girl is a spinster, she is unmarried, but instead of mentioning it as Kumari, you mention it as Srimati, or in Tamil they call it as Tirumati. And instead of saying daughter of, you say wife of. You make the father as the husband. And suppose she is aged 45 years, you mention her age as 65 years. Or she is staying in a particular property, you mention her address something else. Then you take the property that is sought to be sold or transferred under parent document. It has a separate description. Instead of 45, you mention it as 48. Instead of survey number 91, you mention it survey number 98. And the Sari Abdulu, as they call it, or the boundaries, and just like all of us have a description as saying Mr. A, son of so and so, age so and so, occupation so and so, resident of so and so, in the same way, a property also has a particular description. Normally, what you write in the schedules are all that piece and parcel of the property bearing house number so and so, on plot number so and so, in survey number so and so, admeasuring so and so, situated at so and so place, bounded on the north by so and so, south by so and so, east by so and so, and west by so and so. Suppose there is a mistake in the parent document. In various, what is called the description of the property is not properly given, boundaries are not correctly shown, or the description of the parties are not correctly shown, or it has happened because of an inadvertent error while feeding it on the computer. The normal process is normally, I just give you an example. Suppose a child takes the progress report from his school and shows it to his father for signature. Then what this boy cleverly does is he alters 3 into 8, 6 into 8, 9, and various figures are altered. Then when his father sees the report, wow, my son has got 90 marks in mathematics. Very good. Then 6 is made into 8. Then he says, I has got 80 marks in English. My son is extremely that means he takes credit for that. But he does not know that the son has altered the marks in the progress report which is shown to the father for signature. But please remember, original record is there where the correct marks will be shown. So there is no alteration there. So once there is no alteration, for all official purposes, whatever is entered in the official records is only the correct entry. So that is the reason the correct description has to be shown. In the same way, when a lady is a spinster and she has been shown as a married woman, or her age has been shown wrongly, or her address has been shown wrongly, or the description of the person who has executed the document has been shown wrongly, or his father's son of or her wife of so and so, everything is not clearly mentioned, or in the body of the preamble, or in the second page, as you may call it, the correct description of the document through which your vendor or your transferor has acquired title is not correctly mentioned, or the date on which he has obtained the title to the property is not correctly mentioned, or the schedule of property which describes the property with the boundaries have not been clearly shown, then the only remedy open to you or the revenue entries are wrongly made. You want the wrong entries to be deleted and corrected with the correct entries, then the only remedy that is open to you is to go by a rectification deed. Earlier, what used to happen is the beneficiary, whoever is the transferee, himself can go to the registrar office and get the rectification or ratification deed executed and registered. But now, in after 1990 or 1995, it has been made clear that unless both the parties are present at the time of execution and registration of the rectification deed, the document cannot be registered. Sir, what are the documents you have to file at the time of rectification, sir? You will have to file the parent document, and also you will have to file what has to be corrected and clearly mention it. But now the only method that is open to you to get the corrections made is to file a suit under Section 26 of the Specific Relief Act and get the wrong entries or wrong particulars corrected. This is what is called rectification, or it is called correction, or it is called correcting the errors. Then, in that case, when the parent document is submitted, it is also endorsed in the ratification deed or the rectification deed, as you may call it, that the parent document number so and so is corrected as follows. Then the corrected document is given to you in the form of rectification deed. And suppose the rectification is not done, you can always knock at the doors of the civil court and file the suit under the provisions of Section 26 for rectification. Then you may ask me the court fee that is liable to be paid as far as rectification suits are concerned. Please remember, under Section 43, that is 4.3 of the Court Fees Act, the court fee which you paid in respect of a rectification suit is 15 rupees, 1 5, not more than that. That is as far as rectification is concerned. Then you can ask me, sir, what are the documents which constitute the documents of title as far as a person is concerned? Then it is said it is not only the parent document but also the rectification deed which makes the necessary corrections, and the necessary corrections are also made in the books of the registrar for all practical purposes. The parent document with the necessary corrections under the rectification deed forms part and parcel of your title. Am I making myself clear to you, please? This is what Section 26 deals with. Then we go to Section 27 and 28. That speaks about rescission of contract. RESCISSION. Recession. The word recession comes from the word resigned. Resigned, the dictionary meaning of resigned is avoid, retract, revoke, or take back. That is what is called rescission. The process through which it is done is called rescission. All contracts vitiate where the remedy of rescission lies, it is voidable, not void, please. Voidable. What do you exactly mean by voidable? Voidable means exercisable at the option of the party who is victimized. Exercisable at the option of the party who is victimized. To illustrate this particular position, I'll give you an illustration. Suppose, let us say, A makes a contract, A makes an agreement with B saying that he will sell 150 acres of land situated in a particular survey number, situated at a particular place to the vending. It is found that the vendor had a title only to the extent of 100 acres. And regarding 50 acres, he has no title because those 50 acres does not belong to him, belongs to his sister or belongs to his wife. Then in that case, he receives the full consideration and assures the vendee, don't bother, sir, you have paid me the entire consideration. I will try to persuade the real owner, that is my sister or my wife, to execute the documents conjointly along with me, and I shall part with 150 acres of land. Please remember, in law we have got a maxim called nemo dat quod non habet. What do you mean by nemo dat quod non habet? No man, again I repeat, nemo dat quod non habet. NEMO dat DAT quad QUOD space non NON space habet HABET. Nemo dat quod non habet. That means no man can pass a better title than what he himself has. That means no man can pass a better title than what he himself has. I'll give you an example in Telugu. Telugu, there's always saying, Akka somu already danam chesalevu, or Nana ke dukaan mein Lala ke Fatiha. That means when the property does not belong to you, you are very, very philanthropic. You are very, very generous because what you lose, some other's property you are trying to sell, you have no title to that. But whether the person who purchases the property gets title, sir? No. Why? Because you yourself, you do not have title. You cannot pass a title to the. That's right. In the same way, recession, what do you mean is, suppose this fraud is known to you later, you can resign from the contract and say, sir, whatever money has been paid by me, please return the money. I don't want to go ahead with the contract. Why? Because you have played a fraud on me, misrepresented the facts to me, and also misled me, saying that you are the owner of the property. I've acted on your representation, which I would not have done, and given my consent to enter into a contract with you. I want to avoid the contract. Then, in that case, suppose let us say I want to avoid it as a purchaser. I'm saying I'll come to seller later. As a purchaser, I want to avoid it. Then what I should do is whatever what suppose let us say the question is whatever monies have been paid by me to acquire that property, that money has to be restored back to me by the seller by way of restitution, whereby he has to restore it. No one can enrich himself at the expense of the other party. And if you want to avoid a contract, be it a seller or be it a buyer, you must be prepared to do your part of the contract. What does it mean? Here, you have not obtained the consent of the real owner of the property regarding that 50 acres of land. Then, in that case, if the full consideration is paid and I am at the bona fide impression that you have got title to the property, then that money with damages has to be given back to me in case you want to avoid the contract. But you cannot keep the money with yourself and refuse to hand it over to me. Suppose, let us visualize another situation, sir. Suppose a contract gets frustrated or impossible of performance, and in that case, suppose, let us say, I've received some benefits as a seller, and as a seller, I cannot do it because let us take the liquor business, sir. Liquor business, the government is playing with that policy time and again. That is, they say there is no prohibition. Anyone can consume IMFL by purchasing it from the liquor shop. But later, the government changes its policy and also what is called, they say prohibition is introduced, whereby sale and purchase of liquor is prohibited. Then, in that case, whatever business was lawful hitherto has now become unlawful because of the policy of the government. Then, in that particular case, the contract gets frustrated. It is not possible to implement the contract. Then, in that case, when it becomes frustrated, when you have to necessarily avoid the contract. Then, in that case, if any monies are had and received by the seller from the purchaser, he has to restore back that money back to the purchaser. That means law prevents what is called unjust enrichment. Then again, I wish, sir, suppose let us say an agreement of sale is made saying that the advance is paid naturally without paying advance, no one enters into an agreement. And the balance of the sale consideration will have to be paid strictly within 60 days from the date of agreement. Let us say it is not paid within 60 days. Then in that case, sir, what should you do? You can give a notice revoking the agreement and say that I'm not bound to sell the property to you. Since you have violated the terms of the contract, I want to resign from the contract. Then in that particular case, since I wants to retract from the contract, I want to resign from the contract. I want to exercise my right of rescission as far as the contract is concerned. If whatever monies I have taken from you by way of advance or subsequent money, I have to restore it back to you. That is the principle of rescission, sir. In English also they say, suppose let us say you have to get something by toil and sweat. Unless and until you toil and sweat, you do not get that particular property. In the same way, in case you want to In case you want to avoid the contract being a seller, then in that case, whatever monies are had and received by you, when you're exercising your right of rescission, because the balance of the sale consideration has not been paid within the time frame, then in that particular case, you have to restore back the benefits which you have had, the monies which you have had and received from the opposite side, that is the advance and earnest money stands, have to be repaid or refunded to the purchaser. Are you able to understand, please? This is what is called recession of contract or recession of contract or recession of contract, whatever it may be. Then we go to the next doctrine, the most important doctrine in this specific relief act, called as cancellation of instruments and decrees. What do you mean by instrument? Instrument. Excuse me, please. Instrument has got different connotations and different meanings. From the point of a surgeon or a doctor, the instrument means the implements which he uses in performing his day-to-day duties. As a surgeon, the forceps, scissors, the cotton, and other things which he uses in performing an operation are called instruments. And as far as a barber is concerned, his instruments are, nowadays it's very, very easy, sir. You go to a haircutting salon, what is used is a barber's comb and that scissors which is used, and your hair is trimmed. And then again they use a cutthroat and then try to correct your sideburns, etc., etc. Or the shaving razor, which is used by a barber, along with the shaving cream that is used for applying it before the shaving is done, or the aftershave lotion or perfumes which are applied to your body after the shave is over. They are all instruments as far as the barber is concerned. As far as a washerman is concerned, instrument means the stone on which the clothes are washed, or the soap which he uses for cleaning your dirt in your shirt or your sari or your petticoat or whatever it is. And the other things that is, I don't know now whether they use that big hammer like thing to wash it with that or beat it against the stone in order to see that the dirt vanishes. They are all instruments as far as the washerman is concerned. As far as a Kamsali is concerned, the person who does this goldsmith business, as far as he is concerned, he has got his own tools with which he performs his duties. Then you go to a lathe machine. Please unmute, please. As far as a lathe machine worker is concerned, he uses a lathe machine and works on the lathe machine and does the job. So different people have got different instruments through which they perform their respective avocations. As far as an advocate is concerned, for an advocate, please, Hindu girl, as far as an advocate is concerned, the instruments for an advocate is the pad, pen, and also the necessary books which he uses for carrying out his day-to-day duties are instruments. So in this way, instruments are of different types. But as far as the specific relief act is concerned, section 31 to 33 deals with the topic called cancellation of instruments and decrees. Here, when we'll deal with Contracts Act, section 6 says, what are the basic essentials of a valid contract? One is offer, another is acceptance, another is consideration, another is capacity, another is consideration, another is free consent, and another is legality of object. These essentials are absolutely necessary for a valid contract. And I think you know the proverb also, an acceptance an acceptance is to an offer what a lighted match is to a train of gunpowder. What do you mean by that proverb? It means, suppose you have a big tray in which gunpowder, I think, which is stored. And then, so long as the gunpowder remains without being ignited, gunpowder remains. But once you once you light the matchstick and then apply the matchstick to that particular gunpowder, there's a big explosion and nothing is left. It is reduced to ashes. In the same way, when an offer is made and it is accepted, and then every all the ingredients, let us presume, are present as far as a valid contract is concerned, then you cannot retract back from that. But here, section 31 to 33 visualizes a situation where the consent is not free and is vitiated by certain sections of the Contracts Act. For example, section 15 to 22 of the Contracts Act. Can you tell me what's the first one is coercion, another is misrepresentation, another is fraud, another is undue influence, and another is what is called the mistake, unilateral and bilateral. Let us go one by one. Coercion. What do you mean by coercion? Coercion means where you lock a person within closed doors, put a knife on his neck, and then say, "Please sign this document. Unless you sign this instrument, I am not going to let you free. I will kill you at any moment." Or he tries to kidnap the daughter of that person and keeps her in illegal custody, or tries to threaten everyone in the family. For example, I think you must have seen the movie Chettis Gante. In that, the entire family is locked in a room and they are not allowed to go outside. And that cell, and in those days, landline only was available. The landline also was cut so that there is no communication from outside, and people, you are threatened at gunpoint or knife to do a particular thing which you would not have done but for that particular threat. Please remember, threat doesn't mean threat only to you. Threat also means to your other family members. Please remember, all of us live in a society. We are answerable to the society. And we are bound to take care of your wife, care of our wife and children. Their safety is also more important for me. Then, finding no other alternative, I sign a particular instrument, be it a promissory note, be it an agreement, be it a sale deed, be it anything. Then, in that case, do you think that the consent is free, sir? Have I voluntarily consented to it? No, because I've been put under fear of threat, like threat to my life and property. I was compelled to sign that instrument. My consent is not free. Then, in that case, the contract is voidable. Immediately, what I do is when I get scot free, I give a police complaint. FIR is registered. That means I also make it in the complaint, sir. This instrument has been taken from me by force. It has been taken from me by coercion. Please try to book a case against the opposite side and take back my document. That is what is called coercion, where you put the other person to fear of threat, injury, or to his person or property. But in England, it's something more drastic. They use the word duress. What do you mean by duress? Some of you who are working in the factory or in industry indulge in a legitimate weapon called gerao, Gerao. Gerao is not a legal English term, but it's a word from Hindi which is taken out. What do you mean by that? You lock up the doors of your managing director, put a knife under his throat, and say, unless you agree to the demands made by our union, we are going to kill you. And the manager or the MD is not allowed to even answer his calls of nature, and is locked in a room and a wrongful restraint, his consent is taken and some signatures are taken in a document. They are all vitiated by what is called duress. When you try to prevent a person or try to curb the liberty of an individual from moving from his seat, it is called duress. But in India, coercion means putting him under threat of injury, threat of death, threat of fear, threat of bodily harm, or threat of harm to the property. It is called coercion. Then the next term is what is called misrepresentation. Misrepresentation means where you make a statement recklessly, carelessly, negligently, without verifying its truth or otherwise, or you try to make a statement which to mislead the opposite side, we say it is misrepresentation. Where you try to make a statement without verifying its truth or otherwise, or genuineness or otherwise, in order to mislead the opposite side and gain for yourself. It is called misrepresentation, however innocent it may be. But if you go to fraud, it is more dangerous. What do you mean by fraud? Intentional concealment of material facts, suppression of material facts, or facts made with an intention, or deceiving the other side, or, or committing a fraud on the other side, or making a benefit for yourself and to act to the detriment of the other. It is called fraud. That means where a statement is made, where you know that it is not correct, where you know that it is false, in order to mislead the opposite side, and the other side acts on your representation, changes his position, which you would not have done but for your representation, then we say the representation that is made is fraudulent, and the consent that is given is not free and fair, and the contract is voidable. Then we go to undue influence. What do you mean by undue influence? You know, in this world, we are not as independent as we like. That means one person is in a fiduciary capacity compared to the other, or in a dominating position compared to the other, and obtains the consent of the other person, and the other person would not have consented, but for the influence that is used on him, then we say contract is vitiated by undue influence. I'll give you examples, sir. Husband and wife. The question is, husband is more dominant than the wife, because we know that the wife is always dependent upon the husband for living in the society. I think if you know, I'm talking about yesteryears, please. Yesteryears, there was no economic dependence. Wife was depending on the husband for maintenance and for upkeep. But now we know that the wife is more educated, wife earns much more than what the husband earns, or the wife is in a superior position compared to the husband. And it is, of course, please pardon me if there are ladies, please. They say that the wife is in a position to dominate the uh, will of the husband. Then we say, of course, they use the word, of course, it's not correct, Joruka Gulam. That means whatever the wife says, this man only nods his head and says, yes, that is correct. So wife is in a position to dominate the husband, or husband is in a position to dominate the wife. Then guardian and ward. Guardian and ward means the father and son. Then comes the guru and the disciple. Here there's one leading case, sir. I will just cite it because it is one of the law of contracts under the head of undue influence. The famous case of Alcard, A-L-L-C-A-R-D, A-L-L-C-A-R-D, A-L-L-C-A-R-D versus Skinner, S-K-I-N-N-E-R, S-K-I-N-N-E-R, Alcard versus Skinner. Skinner was the mother superior and head of the church. Then Alcott, who was fed up with life, wanted to renounce the worldly life and join the church. And when she joined the church, rosy promises were given to her that she'll be emancipated and she'll reach the foot of, reach the blessing, and she'll get the blessings of Lord Jesus Christ, and also surrender herself to Lord Jesus Christ and attain salvation. But one condition is, when you come to the church and join the church as a nun, you must renounce all your properties and also lead a celibrous life. That means you shall not get married, or you shall not get attracted to any male, or have any conjugal relationship with a male. Then this girl, unfortunately, completely under the influence of the mother superior, surrendered all her property and dedicated it to the church in favor of the mother superior. Then later on, after 7 years, she developed a love and affection for the worldly life. She also wanted to lead a married life, and she wanted to leave the church. And in the meanwhile, she wanted to get back the properties which is dedicated to the mother superior, and asserted, sir, I was always under the influence of the mother superior, and I succumbed to her demands, and I surrendered my property. I'm now fed up with a nun life, and I want to get out of the church. Please restore my property, because it is vitiated by undue influence. And she left the church, and after 3 years she filed a suit. Then the question arose, sir, having dedicated the property to the Mother Superior and given up all the worldly pleasures, can this lady get back the property on the ground of her consent not being free and vitiated by undue influence? Then the courts in this case said was, uh, as soon as she has got out of the church, she should have filed the suit. She waited for 3 years, and after 3 long years, she realized that she has committed a mistake and that she has been taken for a song by undue influence, and she cannot get back the property because she is capable of getting independent advice outside. So, in other words, yes, in other words, if a contract is vitiated by undue influence, and of course, if you take the case of a company also, undue influence also plays a very important part, because under the Companies Act, though a company is incorporated under the provisions of the Companies Act of 1956 or the present Act of 2013, a company acquires a separate status and is a corporate entity and does not depend upon the life or lives of its members for its existence. But you know the first case on the Companies Act also, even one man companies can exist. There's a famous case of Salomon versus Salomon Company Limited, whereby even a single person can run a company. You cannot say the company is the individual and individual is the company. No, even the last shareholder dies, the company knows no death. It has got a perpetual succession and a common seal, and it is called the Ajata Shatru. It cannot be defeated unless it is wound up by an order of the court. Then going further, sir, even the company, though a company is a body corporate, it is an independent entity. It requires a human agency to run its day-to-day affairs. A company operates its affairs through that human agency or the board of directors, headed by the managing director. And also, along with that, you get the shareholders, the creditors of the company, so on and so forth. Then the company, the directors are in a fiduciary capacity compared to the shareholders, and the shareholders, when they have been misled by the prospectors, can always make the company liable for misstatements made in the prospectus, or otherwise so many things. That means the company is in a fiduciary capacity compared to a shareholder. The shareholder completely depends upon the directors for guidance, and the directors take them for a ride. Then in that case, the individuals can complain of what is called undue influence and say that that because of the dominating position which the board of directors had over him, or the stranglehold which the board had as against him, he wants to avoid the contract. They are all instances of what is called undue influence. So, what is the criteria, sir? When one person is in a fiduciary capacity, that means fiduciary means a dominating position, a dictating position compared to the other, and the other person succumbs to the dictating position of the other side, changes his position, which he would not have done but for the influence that is brought on him, then it is called vitiated by undue influence and the contract is voidable. But it has to be done at the earliest available opportunity, as held in that leading case which I discussed. There is Alcott versus Skinner. Then the last one in the vitiating elements is mistake, unilateral, and bilateral. We'll come to bilateral, then we come to unilateral. Bilateral means there is what is called consensus ad idem. That means consensus ad idem means the consent should be free and transparent, and both of them should agree on the same thing in the same sense. Suppose, let us say, uh, I enter into a contract whereby, or enter into an agreement whereby I expect that, let us say, the vendor has got three properties: one at Banjara Hills, one at Jubilee Hills, and one at Hyderabad, one at Old City. Then, when I enter into the contract with my seller, I think that the property which is going to be sold to me is the property at Jubilee Hills. But it turns out that The property is at Old City. That's according to the seller. Then here is a mistake, not committed by the seller, but it is committed by you because you are mistaken. You are mistaken regarding the identity of the property or the location of the property. Mistake is only on one side. That is one side love. That is, unless you have love from the other side, there is no love at all. So there's one side. Pardon? So then we come to that is one-sided. One-sided. That means where the mistake has been committed by you yourself, but other side is not a party to it. Bilateral means where the mistake is committed by both the parties, then in that case it is called a bilateral mistake. Then on this particular aspect, suppose let us say, normally we people believe in Vastu, isn't it, sir? Nowadays, Vastu has become a big madness now. What they say is, yeah, you should not have any weight in the northeast, that's the Isanyam. Or you should always keep your kitchen should be, a platform should be in such a way that the gas stove should be faced southwest. Or the god's idols which you keep should be on a particular position. Or your bedroom, it should be there, it should be in a particular position. Or your attached bathroom, which is there, it should be in a particular position. Then we alter it and do anything. So bilateral means where the mistake is committed by both the parties, then it is known as bilateral mistake. Then in this particular case, there must be identity of the subject matter, number one, and identity of the person with whom we are contracting. In this particular case, there is a leading English case on this aspect, the case of Blenkarn, Blenkarn versus Blenkiron and Company, Blenkiron. Blenkarn, Blenkarn versus Blenkiron, Blenkiron and Company. Here, what happened was, a person entered into a contract with a fraudster called Blenkarn. And Blenkarn, because the name of Blenkiron and Company also was almost similar, he thought that he is entering into a contract with a person with a reputed company called Blenkiron and Company. There was no consensus addendum. He never thought that he is entering into a contract with Blenkarn, but Blenkarn in his capacity of Blenkiron and Company. Here there is a mistake committed unilaterally on the part of the contracting party, that is there is a mistake as to the identity of the person, then contract can be avoided because it's a mistake. That's what section 21 and 22 of the vitiating elements stipulates. So these are the background from which we will discuss 31 to 33 of the specific relief factors. With this, I terminate my lecture today, and I now call upon you people to participate in the interaction session, please. Yes. Any questions?
I have a question, sir.
Yes, Mr. Muralidhar.
Now, if it's a property is sold to a person and first charge, again he sells it to 2 or 3 persons.
Yes.
When they are the property.
Yes.
The first man with
See, sir, there is a maxim here. Yes, I'll clarify, sir. There is a maxim in Latin called qui prior e tempor, potier e causa. That is, who is prior in time normally prevails. But here, suppose one property is sold to B. Let us take an hypothetical example. Suppose the same property is sold to C and the same property is sold to D. This is very, very common in our Hyderabad, sir. The same property is sold to 3 persons. All the 3 persons will be knocking at the doors of the court and then trying to assert their title. But normally under the law, qui prior e tempore potier e jure means one who is prior in time. That is what is called doctrine of priorities as far as section 47 and 83 of the 78, 78 of the Transfer of Property Act, which says one who is prior in time normally prevails. The subsequent documents which are executed during the subsistence of the earlier document, they do not have any title. nor they can claim any title to the property. Only thing is they have to claim damages from the person who has sold the same property and they have been defrauded, but they have no relief against the prior purchaser. Am I making myself clear to you, please? That is the reason why a maxim also is provided in the Sale of Goods Act as well as the Transfer of Property Act. It says caveat emptor, CAVEAT space emptor, EMPTOR. When you purchase a property, buyer has to take all precautions possible as a prudent man, make all discreet inquiries, also obtain all the documents, and also take the encumbrance certificate or what is called the Takattu Patram, and also the linked documents, and also verify regarding whether the title of your vendor is perfect and clean, or the schedule mentioned therein is true and correct, or whether you are going to be taken for a ride. Then you obtain a legal opinion and also give a paper publication. And if seller keeps quiet but sells the property to the second and third parties, then in that case you have taken all precautions. And in that case, because of the maxim fee prior a tempore cotier a causa, cotier a jure, that means one who is prior in time normally prevails. That is the reason in Hindu law also, the first wife is the legally wedded wife and recognized under Hindu law. But the second wife can only be called a concubine or she can be called a mistress. She has no legal rights, please. Am I
Okay,
making...
then can they stop? Suppose if he doesn't pay the damages, what about the property? Can they have any stay on that
He will have
property?
he'll have a lien over that property. He can enforce the charge by getting that property sold, sir. Am I making myself clear?
It's clear now. Then
That's
they
the
say
reason. That's the reason. Please remember, that's the reason
Ah.
why banks have now opened their eyes. You know, suppose a document is registered, sir, it will be entered in the encumbrance certificate, isn't it? Suppose, let us say, it is
Yes.
not registered, it will not be found in the encumbrance certificate. And normally banks resort to equitable mortgage or mortgage by deposit of title deeds. In that case, only the title deeds are deposited with the bank as a security. But there is no corresponding entry in the encumbrance certificate that such a document has been deposited. That is the reason why now banks they have opened up by saying even a mortgage by deposit of title deeds, please register the document and deposit with the bank. Why? Because the bank's interests are protected and their registered document is found in the encumbrance certificate. And also one more precaution is whenever you are the counsel for the bank today, the banks are adopting a policy called you must make a search report, go to the registrar and find out whether this property has been registered properly or whether the registration number is correct, whether the description of the property is correct, whether it is found in the books of the registrar, whether there are subsequent transactions in respect of that property, and then take a certified copy and then file a search report and give your opinion regarding certificate of title. Only then the documents are passed by the bank, sir.
Yes.
This problem is only in Hyderabad, sir. Same property is sold to 10 people.
Yeah. So they can be case also, cheating case also can be raised against
Definitely. But a civil liability also arises, isn't it, sir?
When the advance is taken, if contract is failed,
that advance has to be returned back. Advance has to be returned back. But please remember,
he says that it can't be returned seized.
See, sir,
has to return back.
Human ingenuity is to such an extent today. You know, you are supposed to give your Aadhaar number. You are supposed to give your cell number, and you are also asked to give a Xerox copy of your Aadhaar card or your address proof in order to get the document registered. But what is happening now is, human brains, what they do is Aadhaar card, instead of Indumati, some other lady impersonates as Indumati and puts her photo there. As many Aadhaar cards can be obtained, sir. Am I right or not?
Yes, right.
Yes. Next.
Sir.
Yes, sir. Please tell your name, sir.
MS Rao, sir.
Satyanarayan Rao. Yes, sir.
Satyanarayan. Sir.
Yes, sir.
There any validity for this special power of attorney, sir, from the date of signing?
Sir, as far as special power of attorney is concerned, there are two types of attorneys. One is called special power, what is called SPA, that is special power of attorney, and another is called general power of attorney. Special power of attorney is only for one act. It's only for one act. as far as GPA is concerned, it is for all acts. It is a
Okay.
something like third-party insurance and comprehensive insurance.
Yes, sir. What is the validity, sir? How many days
Validity
after?
is so long, there is no question of time, sir. So they'll say nowadays
Sir.
they are writing as irrevocable general power of attorney. Irrevocable,
Sorry.
irrevocable the
Yes,
right,
sir.
especially in a development agreement. Why? Because the power of attorney spends the money, he finances the construction, he spends his money, obtains the sanction, does the liaison work, and out of the constructed property, he gets 60% and the owner gets 40%. So in that case, because his interest in the property is involved, it goes to the extreme case saying, even if the principal dies, the power of attorney survives because of the provisions of Section 202 to 217 of the
Sir.
Contracts Act, which speaks about agency by necessity.
Sir, son given a special power of attorney to his father in India. He is in US.
There's
Son
no-
is
there-
taking
there
US
is-
and is given PA, and it was validated in the concerned district register. Then how many days the validity is?
Validity is till yes, till it is revoked.
Yes, sir. Till
Till
it is revoked.
revoked and cancelled.
Acha. So till that time it is valid even 2-3 years. 5 years.
Definitely. And if it's to be
So-
revoked, it should be by a registered instrument because the power of attorney is registered.
Power of attorney is validated because that was given given a signed there, and after coming over to India, it was validated in the district
If
register.
it is validated, again the same process of cancellation by devalidating it. Devalidating.
So till the cancellation of that instrument, it is valid. SPA is valid.
Yes, sir. It's
Thank
only
you,
for
sir.
one act.
Yes, sir.
No, that if a GPA, if he says that I'm in America, if he sends a mail that I can't come to India, but it's cancelled. As soon as when I come to India, I will revoke it in the.
Then it
registration
has to be
office.
attested by the consulate in America.
Yes, it should be cancelled by the attestor there.
Consulated there and then validated here. Next, sir.
Sir, in the same
In that case, you must also give a paper publication, sir, to alert the public.
Acha, that means the particular GPR SPA is cancelled.
Cancelled. And no person should deal with it.
Acha. While taking no paper announcement is required. While getting
Exactly. So that it
SPA,
amounts to constructive notice to the public at large.
a notary has signed there and he has sent here, and the district registrar has validated
If validated it, then you must devalidate it.
Yes, sir.
Yes, next please.
But till that time, when he has sold anything, it will be valid, isn't it? Already, if he sold, then he cancels.
Because it is in subsistence, unless it is cancelled or revoked.
He has written in that irrevocable special power of
Irrevocable
attorney.
means
It is
irrevocable
candidate-
arises. Yes, sir, please. Irrevocable arises in a case where the power of attorney holder acquires an interest in immovable property.
So he can sell
He can-
property or deal any other.
He can do
even
only. He can do only to the
family
extent. Yes, sir. He can do only to the extent of 60% of his share.
He can appoint any advocate. This man who got this SPA can appoint any advocate, and he can deal land matters or even family cases also.
He can do so.
He can do the family
So
cases
if
or
it's an
all,
SPA,
any
if it's
other.
given only regarding property, he can deal only with the property. If it is given, a GPA is given for all, then he can exercise his powers in all.
SPA was given to deal with all.
Not all. It cannot be given for all. Only regarding one act.
Family as well as the
Not
land
family,
matter.
sir. Suppose let us say
Mainly for the family.
Sir.
Right.
Suppose the document is registered to
Yes, sir.
go to the registrar, admit execution, or take back the document from the registrar based on the receipt, and take the documents for and on behalf of his principal. All these acts can do, provided only regarding that particular property. Other things he cannot do. But general power, he can do anything.
Acha. Even the SPA is given to deal with the family cases like divorce and all other
Sir,
things.
divorce is an act in personam, sir. It's a right available to you only against your wife or against your husband. But
Yes.
in case you are in a foreign country, you can say the
Yeah.
power of attorney will represent you till such time
Yeah.
the case is taken up for hearing. When it comes up for hearing, it is your duty to come to India and give your evidence.
Yeah. That is the till necessary comes, he'll come.
Exactly.
Till that time, the
GPA holder or SPA holder can appear.
Yes, sir. As per the judge, if he wants him to present or by through video also, he can accept.
Video conference.
Yes, sir. So nice of you, sir.
Right.
Incidentally, I am a student at Siddhanti College in 1992.
1990.
Yes.
Very happy after a long time I'm in conversation.
And the same things, sir. We are hearing your voice like that only. The class also is still like this.
His grace of God, sir. His grace of God.
Oh, great, sir. Great.
Thank you. Next, please.
So these acts are very important. It should be, 1 or 2 days, it should be taken specifically.
That's the reason I'm going very, very slow, sir. Again, I'll repeat for the benefit of those who have not attended the earlier classes.
Improvisation also required.
I definitely do it. That's the reason I'm not supposed to teach you the Transfer of Property Act and all in specific relief act. But I've given you the cases also to give you a background how specific relief is applicable, sir.
Thank you.
Welcome. Next, please.
Sir, good evening. This is Anuradha.
Yes, madam.
Again, in the same question, is there any time bar for SPA validation?
So, if you see SPA validation, the Registration Act says as soon as the cover reaches India, 4 months' time is given to you to get it validated. As far as other things are concerned, the validation period is 2 months. But foreign instruments are concerned, 4 months period is given. The only rider is as soon as it arrives on the shores of India, on the basis of the cover, you can get it validated within a period of 4 months. Am I making myself clear to you, madam?
Yes, sir.
Thank
you. Thank you so much.
Huh? Yes, Mr. Sam.
Sir, I have a question regarding this section 26 of the rectification deed, sir.
Yes.
So when you said, is it related to minor errors, sir, or else we can change the name of the parent
No,
document?
sir. Here, sometimes yes, sir. Some discrepancies arise in the parent document, sir, which is not consistent with the linked documents. Let us put it that way, because there are all clerical errors or arithmetical errors or some errors which are crept in. Then all those errors also you can correct it. The earlier position was even the beneficiary can go and get a rectification deed corrected. But later on the things have changed, saying that unless both the person who has executed it and the person in whose favor it is executed, both of them appear before the registrar and sign, then alone the rectification deed will be registered by the registrar. If these options are not available, then the only probability is you have to file a suit for rectification under section 26 of the Specific Relief Act, file the parent document as well as the new document, and then ask the court to correct it.
Okay, sir.
Welcome.
Thank you, sir.
Welcome, sir.
Yeah.
Then 4 years ago, our rectification required for my daughter.
Yes.
Without her presence, that fellow came and did it, and the registrar accepted it. And the boundaries of the plot.
Right, sir.
Rectification deed was issued.
Sir, those are days, sir. Now the registrar's office is very, very strict. Unless both the parties are present, rectification is not registered.
But already registered, it's a valid.
If it's registered, of course, it remains. That's all. Yes, sir.
Yeah, I understand, because this fellow may again do some mischief. That is the reason.
That's the reason you give a paper publication saying that it has been the original parent document has been rectified by document number so and so, dated so and so. Public are hereby informed about this development, so that it's constructive notice to the entire general public, sir.
Yes.
Next,
Good evening, sir.
Good evening.
General question, sir.
Yeah.
Suppose there is an agreement of sale.
Yeah.
And during the waiting period, 3 months or so, there is a fluctuation in the market.
Right.
So one person is advantage, the other person is disadvantage.
Right.
So one person will ask for exercise the right of rescission, and the other person will insist on applying the.
Sir, today, sir, frankly speaking, I was out of station. I was away from city about 300 kilometers away. On this particular aspect, I remember one Bombay judgment which says escalation of prices is not a ground to avoid a contract. However harmful it may be, you get a higher price than what was contracted for. Just because you get a higher price, it doesn't mean you can resign from the contract. You have to perform the contract as and how framed. That's all. Escalation of prices is not a ground.
Yes, sir, but
When I
there's
come
two
when I
people,
come to specific performance, I'll give you that case law also, sir.
Okay. Thank you, sir.
Yes. Mr. Ram Prasad.
Yes, I am Tom, sir. Sir, I have yesterday's doubt, sir.
Yes.
Mandatory.
Yes, sir.
I know
Mandatory
purchase-
injunction
purchase
means,
was
yes, I'll explain about it, sir. It is granted under section 39 of the specific relief. I'm sorry, under 39 of the specific relief act, sir. I have not come to that, but anyhow, I'll explain to you. Here, mandatory injunction. What do you mean by mandatory? The word mandatory comes from the word mandate. Mandate means command. Command means order. Do it. You have not done it till now, you now do it. For example, suppose let us say the municipality is not doing its duty. Garbage is lying on the ground, and the entire sewage water or the drainage water is flowing on the streets, and it has become unhealthy for you to go out of your house. And you have repeatedly told the municipality, sir, this is what is happening, or the HMW SSB, as far as Hyderabad is concerned, please come and clean the garbage. Then in that particular case, the GHMC is bound to maintain hygiene and cleanliness. And if they don't do it, you can compel the authority to do what he has omitted to do by doing a positive act by asking for a mandatory injunction, sir. That is one example. The second example is,
Sir, sorry for the interrupt. Sorry
yes,
for the interrupt.
yes, sir.
I have purchased land in third floor. I have problem due to construction problem.
Right.
Leaking water.
Sir, previously, yes, sir. Previously, you could go to the consumer court, say that there is deficiency of service. But I was told by the recent.
What had happened? Suit filed consumer against the fourth floor.
Yes,
apartment.
yes.
So after filing suit, he sold to another tenant.
Right.
But in return, she told another tenant.
Yes.
So consumer ordered that you are not the consumer, you go civil court.
Right. See, there is a latest amendment which has come to the Consumer Act, sir. As far as the developer is concerned or the builder is concerned, they cannot be made liable in a consumer court. Only thing is you have to go by a civil suit. That is the latest development in Consumer Act.
Okay, sir. Thank you.
Right, sir.
And can I tell my mandate to suit?
You are asking about mandate injunction. I am on that point. Suppose, let us say, please let me please wait. In some places, you don't have underground drainage, isn't it, sir? But the space between the two houses is you leave open space of 5 feet. That is called the SERI, SERI. SERI means conservancy lane, where you let out sewage water, drainage water rather, or your rainwater, or the useless water, you let it on the drain. It is enjoined on both of you that you shall not construct on that particular drainage line or the 5 feet SERI, and encroaching on that, you cannot construct. Even if you do it, it can be removed. And the municipality can remove the impugned constructions also. Other situation is, suppose let us say the other side opens a window facing your bedroom, your right of privacy is lost. Then in that particular case, you are the prior occupier of the neighboring property, and the other side, in order to disturb your privacy, has erected a doorway or erected a window to have a 70 mm view. Your right of privacy is lost, so you can get your privacy espoused by filing a suit for mandatory injunction asking the person to remove the structures. That is what is called mandatory injunction. So acts of omission which is committed either by a local authority or by an individual or the society at large can be removed by filing a suit for mandatory injunction to direct them to do it at their cost. If they don't do it, departmentally, you ask that to be removed. Suppose, let us say, you construct on my property, you encroach about 100 yards of my property and construct a pakka building there. I can ask you to remove those constructions, demolish the constructions, and then do it. That is what is called mandatory injunction.
Good, sir. Thank you.
Welcome. Next, please.
Sir, I have a quick question about this feeding of grant estoppel, sir. Can you...
Pardon? Pardon?
Sir, you explained about feeding of grant.
Feeding the grant by estoppel. Let us say, sir, there is a maxim called nemo dat quod non habet. No man can pass a better title than what he himself has. Isn't it, sir? Atta somu aludu danam jeyaledu. That is lala ke dukaan mein nana ki fatiha. That means when the property does not belong to you, you are very, very generous. But you have no right to do it, but you do it. Then in that case, the person who gets those rights does not get a perfect right because you yourself do not have any rights. Feeding the grant by estoppel in section 43 of the TP Act means on the date when I transfer the property to you, you act on my representation, believing it bona fide that you had title to the property. I change my position, which I would not have done, but for the representation. But later on, let us say, I acquire rights over the property by any mode, by partition, by sale, by gift, or by court decree, or by auction purchase, so on and so forth. The subsequently acquired rights other perfects an otherwise defective title on the date of transfer. What do you mean by that? On the date when I transfer the property, I don't have rights, but subsequently I acquire rights over the property. The subsequent rights automatically gets passed on to you. Isn't it? That is called feeding the grant. In other words, I cannot go back on my grant. I cannot derogate from my own grant by saying on that day I didn't have rights. Today I've got rights. I don't want to honor the contract. That is not possible. That's why Section 43 has been incorporated. When I go to the Transfer of Property Act, I shall deal with it in detail.
Okay, sir. Sir, one more
Yes.
quick question. Is the declaration suit comes under specific relief act, sir?
Yes, sir. 34 and 35, sir.
Okay. Thank you, sir.
Now, after finishing cancellation, I will go to declaration, please.
Okay. Thank you, sir.
Next.
Sir, do you hear me?
Please tell me your name, sir.
Sir, I am Vasantrao from Khammam, sir.
Pardon?
I have one doubt regarding. I am Vasantrao from Khammam, sir.
Yes, sir. Please tell me.
Khammam.
Tell me, sir.
Sir, I have one doubt regarding the specific performance of home.
Sir, I have not come to specific performance as it. I told you that I am reserving it in the end because the biggest chapter is the specific relief act. I'll finish the smaller topics and then come to that topic.
I have one doubt, sir.
Tell me, sir.
Right? I filed a suit for specific performance of agreement.
Under Section 10.
Subsequently, the defendant got filed another suit saying that he executed an agreement prior to my agreement and filed a suit of filing of my suit.
Right.
The plaintiff in the suit is none other than the son-in-law of the defendant who sold the property.
Right.
I think it is fabricated the document and got filed.
Right.
It still remained ex parte there.
Right. Then what?
Then I filed
Tell me.
I filed a petition there to include me as a party since I have interest in that part.
Right.
And is there necessary to include him in my suit also?
Definitely, sir. You have to do it.
And what is the fate of that case?
That will be held to be your second document. He has misrepresented the facts to you. You have acted bona fide. You have acted in good faith. The earlier purchaser has not cautioned you. As a purchaser, you have taken all prudent steps which a normal human being would take. So you get precedence because fraud has been played and that has not been disclosed to you.
In my case also, that the subsequent furniture has to be made part or not necessary.
Better you do it.
I made application there itself.
And also file an application for injunction not to make any further alienations.
Of course, sir, that's not. When he has the knowledge, he has to file the writ petition in my case.
Exactly, sir.
What?
Or even suo moto under Order 1, Rule 10, spelling out your interest, you can get yourself impleaded. You need not wait for the other side to implead you.
Okay, I have to make an application.
Under Order 1, Rule 10, bracket 2.
Okay, thank you, sir.
ఎవరు?
Sir, explain about section 28, sir.
Section?
28, sir.
Just be a bit loud, please.
28, sir.
27 and 28 deals with the relief of rescission of contract. That means where the contract is voidable or the consent is not free, or where there's a mistake as to the identity of the person or regarding the subject matter, whether it's a mistake unilateral or bilateral, or the contract is vitiated by coercion, misrepresentation, fraud, or undue influence, or mistake unilateral or bilateral, the contract is voidable and can be rescinded. But if any benefits are had and received under that particular contract, then the benefits has to be restored back to the opposite side. That is the relief of rescission, please. That's why I said one who seeks equity must do equity. That means whatever benefits are had, when you want to resign or avoid a contract, the benefits had and received has to be restored back to the other side. It is called the principle of restitution, or it's called the principle of unjust enrichment. You cannot have the cake and eat it too. And in case you have to suffer a detriment, you have to suffer both. Unless you do that, you cannot avoid a contract, please. That is doctrine of rescission, please. Next. We have
got only 9 minutes to.
Sir, hello, good evening, sir.
Good evening, Nokia.
Sir, in the recession, sir, may I ask a question?
Please, you're welcome.
Sir, in the recession, just now you said if the contract is
Voidable.
Voidable by all means by undue influence, threat,
Yes,
coercion.
vitiating elements of contract.
We should cancel the contract.
You can avoid the contract, but if whatever benefits you have had and received, either as a seller or the buyer, you have to restore it back to the other side. Unless you restore it to the other side, rescission cannot be exercised.
Sir, restore to other side means?
Suppose as a seller, sir, you have received the advance and earnest money. That money has to be returned back to the opposite side.
Okay, got sir.
Next.
Thank you.
Thank you, sir.
Thank you. We will wind up for today. See you tomorrow again. Thank you very much.